All right, I think we finally have a quorum here, so we're going to gavel in a second. Are we live yet?
Yep.
I just witnessed that.
All right.
I wasn't offered.
Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Thursday, January 16th. We have 10 bills on the docket. We're going to start off with Senator Simon Eyre. Welcome with Senate Bill 123.
Thank you. That's a hard bill to remember. Yeah, I know you got a lot of hearings today. As you know, this is a sponsor-only bill. This bill passed unanimously last year. Got over the House, ran out of time. I've got a cross-follower this year, and I've got strong support in judiciary, so we're hoping it's just going to fly through this year. Just as a reminder, what this does is it creates parity in the hit-and-run provisions and law. I brought my constituent down last year. He lost his wife, and basically all they could give him was a citation of $500 because there were no penalties. And again, it creates parity. And I remember Senator Muse, you don't see him here, but he went up to our constituent last year and talked with him, and that was very much appreciated and heartfelt. So with that, there's no opposition. I'll just leave it at that and ask for your favorable consideration.
Excellent. Thank you very much, Senator, and thank you for bringing the bill back. Questions from the committee?
Thank you.
All right. Thank you very much. Excellent. Thank you, Senator. With that, that'll conclude the hearing for Senate Bill 123. We'll now move on to Senator Kramer. Welcome with Senate Bill 80.
Good afternoon, Mr. Chair, members of the committee. Ben Kramer here introducing Senate Bill 80. And Mr. Chair, I will not take up a lot of your time. I did not request that we have witnesses here for the bill. It's relatively simple. The committee has heard it previously. And Mr. Chair, I'm hoping this is the year we get this bill across the finish line. So colleagues, here's the problem. Right now in our statute, we have an abuse or neglect of animal law in section 10604, and then we have aggravated cruelty to animals. There's one problem where there's a gap, and that is in the instance of an animal that is so neglected that the animal ultimately has to be euthanized. And there is nothing in the law that addresses the severity of the abuse via neglect currently in statute. And this bill seeks to fill that gap. This was originally brought to the committee by the state's attorney in Montgomery County in cooperation with a number of state's attorneys from around the state. Some of them have been here in the past to testify on the bill. And Mr. Chair, would you indulge me for one moment if I just pass out? I received these photographs this morning from, I'll just pass them down the side so everybody can pay. Thank you, Trooper. Thank you. I was going to pass one down each side. These are 4 or 5 photos of dogs that were found just in Baltimore County in the very past few months. And this is exactly what this bill is seeking to address. These are dogs, one of which had to be euthanized because it could not be saved. They were so badly neglected that several, I think 2 or 3, they've been able to save, and that's always the goal, is to be able to save these animals and rehabilitate them. But one of those photos shows one of the dogs that was so emaciated and then abandoned that that dog did have to be euthanized. So the bill before you provides that if a dog is neglected to the point that it needs to be euthanized, and as a consequence of a prior introduction to this committee, there were concerns about, well, what if one veterinarian says the dog has to or animal has to be euthanized and another may have said otherwise? This bill reflects the will of the committee from a prior introduction, in which it now requires that a second veterinarian sign off on the fact that this dog cannot, or animal, I keep saying dog because it's the most frequent issue, that it needs to be euthanized. So it requires 2 licensed veterinarians in the state to sign off. If, and again, this came from this committee, if it is if it's livestock or an agricultural animal, then it has to be the state veterinarian who signs off that, yes, this animal must be euthanized. So that is what the bill does. Again, I am hoping it doesn't happen a lot, that these cases occur. But as you can see, just in Baltimore County alone in the past few months, these dogs were found in this condition. The one other thing that the bill does do that is very important is it affords the court the opportunity to prohibit the individual from being able to have animals, again, going in the future, either for a period of time or, I'm guessing, ultimately it could be done permanently. But that's a very important aspect of the bill. We do that currently under the aggravated cruelty to animals. That is a provision that exists now in that statute, and it would be the exact same provision carried forward into this law should it pass. So with that, colleagues, I certainly welcome any questions, or if anyone has concerns about the legislation, I can assure you that there's been no opposition in the past. I don't know if the Society of Animal Abusers has signed up to oppose the bill. But if they're here, I suspect you'll have the proper questions for them as to why they would not support this legislation to address this very serious concern. So with that, I thank you all very much. And again, certainly welcome any questions or concerns to discuss. And with that, we're missing both the chair and the vice chair.
Thank you.
So I'll
Thank you,
let
Senator
you all
Kramer.
collectively take matters into your own hands.
All right.
Oh, look, we've got a motion for a favorable here.
Does
Senator
anyone
Sidnor,
on the
yes, sir.
committee have any questions? No questions? Thank you, Senator.
Thank you all very much. Enjoy your afternoon.
All right, are we going by the list? All right, Senate Bill 81, Senator Kagan. You're up.
Thank you so much, Senator Sidner. For the record, I'm Cheryl Kagan, very proud to be the senator for Gaithersburg and Rockville. Congratulations and welcome to Senator Love and Senator Henson. Nice to see you here. I'm going to be fairly brief because this committee has heard this before, but I also, it's going to be a little different than years past, and I also want to make sure everyone's up to speed. So Senate Bill 81 is about cyber attacks on our 911 center. This is not fun and games. This is people die when our 911 centers are shut down proactively, maliciously. So this bill sets up 2 levels of penalties. One is if you try to mess with a 911 center. The other is if you succeed. The penalties, in my view, are modest, considering that grandma could die from her heart attack, the house could burn down, the bad guy gets away. The House has passed this bill unanimously twice. It has not yet gotten out of JPR in recent years. It was modified and sent out, I believe it was in 21. There are 2 options that I am presenting today for your consideration. One is this bill that was part of the recommendations of our 911 Commission that I chaired for 4 years, and it just deals with our 911 centers. The other is going to be broader because, frankly, the crisis has increased. I believe at each of your desks you have a map and a list of the 31 other states that have cybersecurity laws on their books. Maryland is one of a diminishing number of states that do not yet have anything penalizing attacks on our infrastructure, on our 911 centers. I gave excerpts from each of the 31 other states that are red and blue and purple. They are Wyoming and South Dakota. They are Pennsylvania, Ohio, California, Nevada, and elsewhere. So 911 centers are the backbone of our public safety system. And yet, whether it's foreign actors or a kid who's bored, people have messed with or succeeded in shutting them down. It was just a few years ago that the Baltimore City 911 center was shut down for 18 hours. I want to just hold that, make sure that that's right. 17 hours. It was offline in 2018, Baltimore City. You all remember CrowdStrike that shut down our airports, our hospitals, our personal computers, our transit systems, and yet no penalties in the state of Maryland are on our law books. We are past the point where this is kind of an interesting bill, and we are at the point where this is a crisis-level bill. Mr. Chairman, welcome back. I just held up 2 sheets that should be on the list of 31 other states that have legislation like this, and a map of all the red and blue states that have this law. There has been an 807% increase in cyber attacks. 807% increase between 2013 and 2022. We couldn't find more recent information. 13 million digital incidents, digital attacks in 2022 alone. So the 2 options I am proposing for your consideration, one is to keep the bill as it is, which would just cover attacks on our 911 centers, attempted attacks, cyber attacks, or those that are successful. The other option for your consideration is a bill that I had drafted, but I decided not to take the committee's time and not to file 2 bills. But it is LR number 1161, and it is a broader version that covers all critical infrastructure and attacks, digital attacks on all this. I'm going to read the tiniest little excerpt that it would cover, quote, critical infrastructure, which means physical or virtual, that are so vital to the state, a county, or a municipality that the incapacity or destruction of one or more components would have a debilitating impact on 1, public security, 2, economic security, 3, public health, 4, public safety. I'm not going to bother you with more than that. So I leave it to the committee's wisdom whether you would like to this year consider moving the narrow bill that just protects our 911 centers or the broader bill to reflect the urgency, the crisis that CrowdStrike woke us up to and cover all of our critical infrastructure. I am happy to take any questions.
Thank you very much, Senator. Questions from the committee? Cold bench. All right.
All right.
Here you go.
Thank you all very
Senator.
much.
Thank you.
Take care.
We'll work on this in earnest. All right, with that, that'll conclude the hearing for Senate Bill 81. We'll now move on to Senator Folden with Senate Bill 122.
Good afternoon, Mr. Chairman, esteemed colleagues of Judicial Proceedings. For you today is Senate Bill 122. And this is regarding criminal law hate crimes provision for law enforcement officers. Basically what this does, in short, this would bring law enforcement officers into a protected class, much like we've done with other classes, so that if there is a direct attack upon them, because we've seen increased attacks on law enforcement just for holding their position within the community, that this would be captured in the hate crime laws. In Frederick County, we had an instance where an officer had his cruiser parked in one of his house and someone had laid a pipe bomb across the lower windshield of the car, and it blew out the front windshield as well as the front window of his residence. The attack was simply done because of the car that was in front of his house. It wasn't about the person, it wasn't about anything else. It was about the job and the walk of life that this person had. So I think this is a pretty simple bill. I think we'll all find great harmony and agreement on this. So with that, I would ask for a favorable report for SB 122.
Excellent. Thank you very much, Senator. Questions from the committee? All right, seeing none, thank you very much.
Thank you,
Senator. With that, that'll conclude the hearing for Senate Bill 122. Oh, sorry, my apologies. We do have an opposition panel. Is Ms. Levy here? We called this slightly out of order, so we will review her written testimony for the file then. So with that, that'll conclude the hearing for Senate Bill 122. We'll now move on to Senator Reedy with Senate Bill 112. Welcome. Welcome back.
Thank you, Mr. Chairman. It's always great to be before you. Do I have a panel? Yes. I also have some written testimony too, but I wanted to be sure I got my folks. Yeah, come on up, please. Or Mr. Chairman, I assume I can call my panel. Yes, thank you. Sorry. Good afternoon, colleagues. Senator Justin Reedy here. Very happy to be presenting Senate Bill 112 to you. It's legislation. I know we have a couple new members on the committee from last year. It's legislation that I submitted last year as well. And it deals with sports officials and the assault part of the code. According to the National Association of Sports Officials, NASO, close to 90% of sports officials report being harassed while before, during, or after a sporting event. And no, I'm not talking about Ed Hockley, the NFL referee. I'm talking about our volunteer or very lightly paid umpires, hockey referees, basketball referees, and lacrosse officials. Over 50% of those sports officials have said that the harassment made them feel unsafe while officiating, and 13% of our sports officials have been physically assaulted by a fan, coach, or player. And I've cited where we get those statistics from in my testimony. Senate Bill 842 wants to make a change in our second-degree assault law to specify that the crime of a misdemeanor second-degree assault includes an assault against a sports official. The misdemeanor could impose a fine up to $2,500 and/or imprisonment not exceeding 10 years. A first offense for a second-degree misdemeanor is not going to lead to a 10-year sentence, but that is the fine that it can go up, that is the imprisonment it can go up to. Now, it's obviously already illegal for someone to be assaulted, whether an official or an individual, and it's illegal to commit assault on another. But sports officials are not currently included in criminal law 3-203 article. And that would authorize a police officer to make a warrantless arrest with probable cause under 2-203, criminal law 2-203. So SB 112 specifies that the assault against a sports official can lead to an immediate arrest with proper probable cause. And in this case, something like video evidence, eyewitnesses, those are the kinds of things, and I know many of the committee know this, but those are the kinds of things that would allow you to arrest for second-degree misdemeanor assault. And we're talking about this because I know we're very careful about making special categories in the law, but sports officials are oftentimes in a maelstrom of dozens or even hundreds of people where they are either the one of them or maybe them and their partner or a couple of partner officials are the only real authority figure in that place. And they're vulnerable. They're very vulnerable at times. And we unfortunately have in this society a lot of people who feel that they're entitled to scream at or berate people. And it's certainly a First Amendment right to scream if you want to, but to actually physically harm somebody or to put your hands on someone is not correct. It's not right. Team sports, which, you know, all of us with children or grandchildren or nieces or nephews, we love the fact that we can go watch our kids play soccer or lacrosse or football. But team sports at every level can't exist without officials, again, many of whom are either volunteer or you know, lowly paid, making a few bucks a game, reffing a soccer game or something like that. So we're asking Maryland to join with this bill, 18 other states, including Pennsylvania, West Virginia, and California, in specifying that sports officials should be included in this second-degree assault criminal law 3-203. So I'd request a favorable report. I do want to point out we have submitted testimony, written testimony on behalf of 26 officials from across the state, and they have some pretty compelling stories. And I have a couple of them here today to share their testimony and their stories. I'm happy to answer any of the questions now, or we can wait till the panel's finished, whatever you'd like, Mr. Chairman.
Should we wait till the end of the panel then?
No problem.
Thank you, Senator.
Good afternoon, Senator Smith, members of the committee. My name is Michael Schilp. I'm the president of Baltimore's Best Umpires. In previous sessions, I've testified before the Judicial Committee detailing the number of sports officials that are quitting at a rapid pace. Today, my testimony will direct you to look at the harm that these officials quitting are doing not only to high school sports, but to youth sports. High school sporting events are being canceled at an alarming rate because of lack of officials. The same goes for youth sports. When these events are being played, they're being sometimes officiated by crews being shorthanded. That creates an environment that becomes challenging and can become dangerous for players and officials alike. Maryland currently has 37,000 sports officials, and what we're asking for is we want to be safe. Senate Bill 112 will give us that safety net. The individuals that create these unsafe conditions know they are safe in the state of Maryland because the law protects them. It's important we show them that the state of Maryland will protect us and not allow these types of assaults to continue without repercussions. In the past, you have heard many officials that were assaulted, and to date, none of them have been prosecuted. We cannot continue to allow this behavior to continue. Maryland is one of, and Senator Reedy, I have the most recent update, Maryland is one of 23 states that does not protect sports officials. The bill will be, that bill will become law, will allow law enforcement to make an arrest based on probable cause. Before this bill, they cannot unless they witness the event firsthand. In closing, there have been numerous written testimonies sent in from officials from all over the state of Maryland, with several of them contacting members of the committee personally and their own state senators are asking for the same request. a favorable report and moving one step closer to protecting those that allow the children to enjoy participating in these events. Without sports officials, there are no sporting events. Thank you for your time and consideration today.
Thank you very much.
Good afternoon, Senator Smith and committee members. I'm Marcus Dent. I'm the president of the Baltimore Orioles Board, RBI. I'm directly responsible for over 43 baseball leagues in the state of Maryland. Right now, we are at an impasse. We have many, many, many officials, not only on the baseball diamonds and on the basketball courts, who are either volunteers or underage. We have a junior officiating committee of 14 to 18-year-old umpires. Their safety matters. Last year, one of our junior umpires was followed to his car, not only having his license for a couple months, a 16-year-old. Summer job. As Senator Reedy already said, he's making about 20 bucks, 30 bucks. They followed him to his car. Last year, we had a fan literally throw items, Gatorade bottles, water bottles, at one of our umpires. As a current coach, we had to explain to our 10-year-olds why that game was canceled, why this fan did this. Our umpire's safety is just as important as our child's safety. Umpires, officials, and the like are there to not only protect the integrity of the game, but to protect our young people. It is our duty as Marylanders to protect them so they can protect those who are actually participating in these events. Youth sports in general is designed to provide an opportunity for our young people to be mentored, educated, and learn doing a sport that they love. These officials come out every single day and every single night to ensure that integrity is met for our young people. I thank you so much for hearing me today, and I ask for your favorable. Thank you.
Thank you all. Thank you, Mr. Chairman. Thank you for coming down. Thank you, Senator Reedy. Amen, and I support everything you're doing, but so don't let my questions ever seem like I'm not supportive of that. I'm just trying to get a couple of factual things. So we are in the middle of the pack, meaning about half the states have some specific articulation of this particular crime, which is already an assault would be crime, but also calling out and specifically highlighting officials who do a very important work. Is that where we are right now?
Yes. I'm sorry,
Something
yeah.
like 23 do and the rest don't, or
They don't have a specific protection.
I think we should be doing so much more. I'm appalled at what I see when I hear in the news about fights that break out between parents, which never seems appropriate. It seems even worse when it's like, T-ball or, elementary.
You'd be surprised at where it happens.
I know.
Yeah, yeah.
So that's not where I'm going, and this is not to undermine this bill, but always when it's a crime, we're getting it after the fact. And hopefully, if someone gets prosecuted and there's some press around it, and you find out a sports official from such and such a high school, was assaulted and a successful process, that you hope will deter. But I am a little worried that we're not doing more, and that this bill would make us all feel better that we've highlighted and recognized your importance and vulnerability. But it is a bit after the fact. So the question is, in the other states, has that law permeated out? Have you looked at and seen that news articles got out there because somebody was prosecuted, and all of a sudden, if they've been on the books long enough, maybe you can, if they were just passed, I know that's a little premature, you can make some arguments to me today that say, look, it did have a deterring effect over time. Can you address that?
I sure can, Senator James, and thank you for your question.
Sure.
I officiate a lot of baseball and basketball in the state of Pennsylvania. Pennsylvania has 2 laws on the books.
Okay.
Pennsylvania has a law that if you physically assault me, that's a second-degree felony.
Yes.
They also have a third-degree misdemeanor that if you verbally assault me, now they can get you for a third-degree misdemeanor. I'll cite an incident that just recently happened. On December 20th, at a sports facility called Spooky Nook up in Lancaster, Pennsylvania. It's kind of where I live. There was a basketball official who was headbutted, broke his nose, and received a concussion from a coach who did not like a call he made in the game. That, when the coach found out that law enforcement was called, he bolted. In Pennsylvania, they have basically the same law that we're asking. Probable cause. They had a parent who had a video. The police officer showed up, looked at the video, took a couple comments from the people that were around. They went 1.5 miles down the road, stopped him, arrested him, and charged him with second-degree felony assault. That's how the law works.
So I think if I read you right, in this testimony right, one of the benefits of articulating your name specifically is that rather than gather evidence, wait several weeks, maybe there's an indictment, and you go, the law enforcement officer is empowered, and I have a law enforcement officer right next to me, so, is empowered because of the way we write this statute and track what others, to immediately, with enough evidence to have probable cause to make that arrest right then, so there's that immediacy of it. Is that the other benefit?
If you don't mind, I'll state something else for you. And several members, I believe Senator West and Senator Sidmore, actually was on the committee, and Senator Smith and Senator Wall-Striker as well.
Well, heck, you have everybody then.
I
think you're good.
A couple of years ago, a gentleman who worked for me, David Collier, and he testified last year, was assaulted. We had a video. He was pushed into a brick wall by a parent, and a parent and son punched him. There was a video taken, and I can send you the video. I still have it. And the police were called. And when the police officer arrived, he basically said, I didn't see it. I can't look at the video. I can't take the testimony of anybody. And the parent left because he knew he was protected. He knew there was nothing that police officer was going to be able to do. Mr. Collier had to go through 3 months of going to the commissioner's office to try to get them to file charges. We actually found out who the child was ourselves because we couldn't get any help, and wound up going to the school where he was attending school to get them to turn the father in.
There is data to support the concept that it's not oftentimes the duration or severity of the punishment, but the swift uncertainty that it will occur that is the most detrimental. And that seems to be what you all are trying to say here today.
And that's correct. And just in Senator Fulton's county a couple years ago, there was an umpire smashed in the face with a frozen water bottle. The police were called. 2 miles down the road, the sheriff pulled him over. He basically told the sheriff, I know there's nothing you can do about it because you didn't see it.
Thank you very much. Appreciate your answers.
Further questions from the committee? All right, excellent. Thank you both very much.
Thank you so much.
Thank you, Senator. With that, that will end the hearing for Senate Bill 112. We'll now move on to Senator Sidner. Are you ready to go? Senate Bill 142.
I'm the same one. Where's
From Frederick. State's Attorney Frederick. All right. I got all the state's attorneys on this one. Who's the main one? Good afternoon, Mr. Chair, Committee, Charles Sidnor, on testifying on Senate Bill 142. In 1992, our state, now Supreme Court, overturned the Montgomery County Court conviction of a husband, Mike Enriquez, for the second degree of sexual assault of his wife, on the fact that the evidence that he had apologized for his actions and attempted to reconcile over the telephone call, clearly admitting to charges brought forward by the state. The court, referring to a 1977 case of Coleman v. State, wrote, and I'm going to quote two paragraphs and for this reason. The substance of the marital communication in this case was that Enriquez was sorry for his actions. The presumption that this communication was intended to be confidential and not disclosed to the police was simply not rebutted at trial. This is especially so since, as in Coleman, the marital communication amounted implicitly to an admission of a crime. Thus, as in Coleman, the wife was incompetent under the statute to divulge the marital communication over her husband's objection because it was made during marriage and was confidential in nature. In the 15 years since we decided Coleman, and Coleman again was decided in 1977, in this particular case in 1992, the legislature has taken no action to add any express exceptions to the statute. Since the legislature is presumed to know the law and it did not amend the statute, we conclude that it intended that our interpretation of the statute in Coleman should stay. So ultimately, the court ruled Mr. Enriquez's call was improperly admitted evidence and deemed the wife incompetent to divulge marital communication over her husband's objection. The law our Supreme Court was interpreting is Section 9-105 of the Courts and Judicial Proceedings article, which provides one spouse is not competent to disclose any confidential communication between spouses during their marriage. In other words, a spouse is not allowed to share a conversation they had with their spouse in a court proceeding if their spouse commits a crime against them and apologizes for that criminal behavior. Our law characterizes that apology as a confidential communication and therefore not admissible as evidence in court. The lack of an exception when a spouse is a victim of a crime perpetrated by the other presents a significant roadblock to holding spouses accused of criminal acts accountable. Senate Bill 142 addresses this problem that has not been addressed, and even as the court signaled to the legislature in 1992 by permitting but not requiring communications made within a marriage to be admitted into evidence if one spouse is charged with committing a crime against another. This legislation places the power fully in the hands of the victim spouse by providing them with the choice of disclosing such a communication. In conclusion, this bill passed the House unanimously last session and was heard by all of us, but failed to be reported out of this committee. It is time for Maryland to join the 41 other states in protecting and empowering victims of spousal violence by codifying this vital exception in the spousal confidential communication statute. For the above mentioned reasons, I request a favorable report, and I believe we have two witnesses, I believe one in person and one virtual. Oh, is it two? All right.
Yes, come on up.
All right.
And then we'll hear from Ms. Ruth, who is joining us virtually. We'll have the two in-person witnesses, and then we'll switch over to the virtual option. Good to see you, Lori.
Thank you, Senator Sidnor. My name is Brett Engler. I'm with the Frederick County State's Attorney's Office, and on behalf of Frederick County State's Attorney's Office and MSAA, we support the bill. I can't really say it better than Senator Sidnor said. Maryland is one of only a few states that does not have an exception for spousal communications that occur during the marriage when one spouse has been accused of committing a crime on another spouse. So as the chief of the domestic violence unit in Frederick, I often will see crimes such as marital rape, strangulation, felony level assaults, and often the only piece of evidence is that confession, that letter of apology to the spouse by the offending spouse. And when that person comes to trial, that critical piece of evidence is in the hands of the offender. The offender can keep the victim from sharing that with the court and the jury, get up on the stand, say this didn't happen, and not be impeached with that evidence because that evidence is confidential spousal communication. It's unjust, and it keeps the real truth from the jury, and we need to change the law to empower victims, as the senator said. Thank you very much.
Mr. Chair, good afternoon. I'm Michelle Smith. I'm here on behalf of the Maryland State Bar Association, the Family Law Section. I know almost all of you. Congratulations to the new senators on the committee. We are here in favor of Senate Bill 142. Thank you, Senator Sidnor. This is an important bill. I can tell you from the Family Law Section, we support it wholeheartedly. The decision whether to testify and whether these communications should come into evidence should be held by the victim, not by the perpetrator. And I can tell you that as a member of the Family Law Section, as well as being a prosecutor myself for 20 years, specializing in domestic violence, this is an important bill, and we urge a favorable review from this committee, and hopefully it'll get out this year. Thank you.
I'll hear from Ms. Ruth, and then we'll switch over to the committee for questions.
Good afternoon, Mr. Chair, members of the committee. Maybe you can tell by my voice why you don't want me there, and I am home to save you all from this plague that I seem to have gotten. I don't really have anything to add. I will say, until this year, I was at another organization. I am the new public policy director at the Maryland Network Against Domestic Violence, and we fully support Senate Bill 142 for all of the reasons that were previously stated. Thank you.
Thank you very much, Ms. Ruth. Get well soon. I thought you were on the beach. I was expecting some of the wind to be, going through your hair. All right. So we're going to start with Senator Love, then Senator Henson.
Thank you, Mr. Chair. Thank you, everyone, for being here today. I'm actually appalled that we don't already have this in our state law. So 2 questions. One, did you mention how many other states have this? And I missed it.
41.
Thank you, 41. Excellent. And my second question is, I see in the fiscal note that this was brought last year. Is there any other history behind this? Do you know if it had been brought in the past?
Nothing more than what was mentioned in the bill. I mean, in the fiscal note. I do not know.
Okay, thank you very much.
Senator Henson, sorry.
Chairman, and thank you to the bill sponsor and the panel of witnesses. I want to make sure that I support the bill, but I want to make sure I could explain it if I ever get caught into one of those conversations that attorneys have where you deep dive into the underpinnings. As I understand it, the kind of foundation of spousal defense is that or spousal privilege, is that when you get married, you become one in the eyes of the law, and you can't be compelled to testify against yourself. So if you and your spouse are this inextricable one, and you communicate with your spouse, and then that communication is then a part of the record, you in essence are testifying against yourself in a theoretical sort of way. How do we get around that to create this very necessary exception?
Boy, that's a good question.
I'm happy to respond if the chair will allow me.
Yes, please.
Senator, welcome and congratulations. Marital privilege and communication is really founded in England under the common law. When women married men, they lost all individuality and power. And so, yes, they became one. And because of that, the wife couldn't testify against the husband because it would be considered testifying against themselves, as you say. So it's grounded in 100-year-old, I think, fairly misogynistic and old-fashioned views of women, and that they didn't have a voice of their own once they married. And so that's really underpins all of the spousal defense things and spousal communication, spousal privilege. And I think that in today's society, we are beyond that. Thank you.
Thank you. Thank you. Thank you, Mr. Chair.
So a couple questions. We can ask
Somebody
a lot
say
more.
move favorable?
Yeah. No, so a couple questions just, and we can do more follow-up when we kind of workshop the bill later on. But so looking at some of the case notes in the code and some of the notes. So criminal investigations, if the spouse makes a comment to an officer and then that comment then makes it into like a police report, is that police report excluded under any sort of hearsay? Are there exceptions for that police report to make its way into a trial for battery or whatever, or assault?
Thank you, Senator. Chairperson Smith, a spouse is competent to testify against their spouse if they choose to. So there's two different privileges. There's testimonial privilege, which in domestic assault cases, a spouse can claim one time to refuse to testify against her husband or his wife. However, what we're talking about here is a communication privilege. So a spouse may testify against their husband as to facts, as to things, but as to statements particularly, under the current state of the law, the offender and the victim hold a privilege of communication. So the offender could keep any admission out of testimony through the victim's mouth in court.
But because it's divulged to the officer, it makes its way in.
Not necessarily if it's hearsay.
Yeah, that's what I'm saying. Are there hearsay exceptions that would apply?
I can't think of any.
Business records exception or something like that?
I wouldn't think so. So a statement of a party opponent, but the wife's not an opponent, it's the state. So that the relationship between the victim and the offender, because they are married, that admission or something relevant can come out of evidence completely, just like State versus Enriquez. We haven't changed that since 1992, and in a lot of my cases, the most important piece of evidence is a confession, which is usually with some type of please stay, don't leave me, some type of threat perhaps, critical pieces of evidence that we shouldn't be holding from judges and juries. Thank you.
Ms. Smith, were you going to say something?
I was just going to clarify that there could be other exceptions, as you've noted, to the hearsay rule. If the spouse that you're referring to making a statement to the police is the alleged victim.
Yes.
And those are the ways that Ms. Engler and all of her colleagues get evidence in even without the victim present in court. There are numerous exceptions that they use to do that.
I was looking at some of the exceptions, and I was wondering, one of them seems kind of peculiar because the way it's just written, it's just interesting to me. And I don't know if you knew the legislative history behind it. So you can, unless the charge involves the abuse of a child under 18, okay, understand that.
Right.
Assault in any degree in which the spouse is the victim if the person on trial was previously charged with an assault in any degree or assault and battery of the spouse. Do you know the legislative history of that?
Well, I recall when that became law, and it was revolutionary in my practice as a prosecutor, but I couldn't cite to you the legislative history.
I see a state's attorney back there that may know.
Yes. Would you like for him to
Yeah, if you
come up?
could.
Yes.
Because, I mean, I think it actually, to me, it seems interesting. It lends itself to, passing this bill, but, because it seems very peculiar, but I'd like
Sorry, just can't help myself.
Yeah, welcome.
Welcome, Chairman. Very happy to see you. Hope you're all glad to see me once. So the history is that for decades, you could come in and claim the privilege to not testify over and over and over again. So several years ago, somebody said, this has got to end. And so that's when they invoked the you get one shot at this rule, so that when the spouse comes in and doesn't testify one time, then they can't do it the second, third, or fourth time. And so that's how that came about, because we were seeing a lot of these people who were constantly being abused and then constantly not testifying. So it's basically you get one shot at this where you can stay out of it, but then after that we can actually compel you to testify. Yes. They get one chance to not testify.
I understood, yeah.
And then after that, we can compel them to testify.
That's interesting. I'd love to hear the discussions just to be afforded one shot.
Well,
not for the turn of phrase, but I mean,
just like everything, I would like to have come down and say none, but there had to be a compromise where certain members of the bar, particularly maybe family law lawyers, wanted to protect that right, and that compromise was met.
Interesting. Senator West, thank you for that.
Thank you, Mr. Chair. Mr. Schellenberger, I've never heard of a one-shot rule. Is this part of a statute, or is this court procedure?
It's in the statute. It's in the statute.
The one-shot rule is on the statute. The
Yeah, and
spouse
actually,
has one
that's really a
chance of saying,
bad
"I'm not
term
gonna
I used.
testify."
The one chance to claim the privilege and not testify. I can't remember what year it went into effect, but it's been around for a bit.
Isn't that interesting? I've never heard of that before, but it makes sense.
Yeah. Yep. Okay. Thank you all.
Further questions from the committee? All right, thank you very much, Senator. Thank you all. Get well soon, Ms. Ruth.
She'll be back, she's got.
Oh, you've got, okay. All right. Are there any opposition? All right, I think that concludes the hearing for Senate Bill 142. We'll now move on to Senator West. I think you have the, what? Oh, Senator, are you ready to go? Okay, excellent. Senator James, we'll go with you next then.
Good afternoon, members of the Judicial Proceedings Committee. Nice to be with you. For the record, Senator James, representing Harford County, and if it's okay with the chairman, I have two state's attorneys coming up with me, Scott Schellenberg and Debbie Feinstein. This is a bill from last year, and nothing has changed in the language. And during the hearing, everyone present supported it. So I want to just start with that thought. It was a top priority of the state's attorneys, especially the ones that deal with special victims, victims of crime. Maryland is a real outlier here, and Senator West is going to find this very familiar because I think your bill is the one that created the task force to overhaul and review all of Maryland's criminal laws, because we are a very odd and state with a lot of inconsistencies, unfairness, oddities, and quirks. And this bill is addressing just one of them, but it's powerfully important because it's addressing an issue that comes mainly out of domestic abuse. So this sponsor did research last year and this year just to make sure I was still accurate. There is no other state in the nation, nor the federal government, that does what Maryland does, and the gap I want to close. Normally, when a defendant is charged with a crime, he has a right to confront his accuser in court. But if the defendant who is alleged to commit the crime intimidates the witness not to show up, coerces, manipulates, they lose some of that, that protection through a very guarded process, and generally it's an exception to the hearsay rule. But in Maryland, we don't have this protection when the charge is second-degree assault. In just about every other state, second-degree assault is such a serious crime, it's considered a felony. But in Maryland, the way our statute reads to allow for defendants to be held responsible when they're doing witness intimidation, it just was written that, it applies to all felonies. And weirdly, Maryland treats second-degree assault as a misdemeanor. And in the letter that's attached to my testimony that talks about two leading experts that are working on this task force, they highlight this as one of the most extreme things about Maryland's criminal law, this odd thing that second-degree assault, which is up to 10 years in prison, is not called a felony for the purposes of this statute. So I'm going to stop because there's not actually that much more to it, but these state's attorneys live and breathe this. They know the limitation of it, and they have compelling testimony to explain why we so desperately need this law. I hope you will be as favorable as you were last year and, report this committee, this bill out favorably. Thank you, Mr. Chairman. We'll stop, not questions now, right? Yes, so the panel, they like you to stand up, though, and come to that. Because, of course, we can't get you on film as well, I think.
Of course, sorry, it's my first time down here this year. I have to be reminded. Good afternoon. My name is Debbie Feinstein. I'm with the Montgomery County State's Attorney's Office, and on behalf of my office, as well as the Maryland State's Attorneys Association and the Maryland State's Attorneys Association's Special Victims Subcommittee, which Joyce King and I co-chair, I'm here to testify in support of Senate Bill 146. I want to echo what Senator James said about our state being a clear outlier. In most other states, they've codified the federal rule, which is Federal Rule Rule 804B6, which allows for the testimony of an out-of-court statement made by a victim of crime to come into evidence when the suspect, when the person on trial has intended to and has procured their unavailability through some sort of wrongdoing. And as I said, many, many states have either codified the federal rule or it's been codified essentially through case law. And happy to provide more specific information if people want, but as I know you did, thankfully, and I thank you for voting this out last year. A couple of other things I would note. Crawford, the case that really constitutionalized the right to confrontation, carves out forfeiture by wrongdoing within that law. Giles, which followed Crawford, again memorializes the right to use these statements where the defendant has forfeited their right to confront. So this is well memorialized in case law, in statutory law across the country. I'm not sure why Maryland elected to have this exception, have it laid out the way it is in courts and judicial proceedings, the courts and judicial proceedings section, but our rule 804B6 actually refers back to courts and judicial proceedings as opposed to standing alone and handling forfeiture as it should and as the vast majority of the country does. I have several examples. I see I'm running out of time, but just one quick example of a case in my jurisdiction. You're dead, you got me locked up, you better do everything you said, or mother's gonna be, or you're gonna be knocking, or mother will be knocking for it, meaning I'm gonna harm you. Told her don't show up, or if you do show up, lie for me, you owe me your life, you're dead to me, and all sorts of threats towards her, and specifically told her not to testify and come to court. And I could give you numerous examples. Another case where the defendant's prepping the victim on the phone, telling her not to come, and there's really it's arbitrary that misdemeanors aren't included. And second-degree assault really stands out as one of the ones where we really could utilize this really important change in the law. So thank you for your time, and I would urge a favorable report on Senate Bill 146.
Chairman Smith, members of the committee, Scott Schellenberger, State's Attorney for Baltimore County. So you all passed criminal CJ 10901 many years ago, in which you said, look, if you're charged with a felony and you manipulate the victim of that felony in some way or threaten that person in some way, and they decide not to come to court, then you shouldn't be rewarded by not being able to use the statements that the individual made. Well, it just so happens, what kind of case does this happen the most times in? Well, domestic violence cases. And what are most domestic violence defendants charged with? Assault and battery, which in Maryland is a misdemeanor. So it absolutely would takes away a tremendous amount of power for us to be able to do anything. So you can imagine that police come to the scene, there's a 911 call in Baltimore County, and soon everybody in the state will have a body camera on, and they're going to walk up to the person and say, you know, what happened? And the person, if it might not be an excited utterance, so they might not have another exception, and it'll be, well, he hit me. And then you are listening to jail calls, as the state's attorney indicated, and you can't even believe that you hear this, don't come to court, I don't want you to come to court. And you know, you have to remember that these people are typically sharing a home, sharing children, they may have already been subjected to violence before, and therefore they will decide not to come in. It defies logic that we would say, oh, if it's a first-degree assault, we can use that statement, but in the thousands and thousands of cases that are charged as assault and battery, nope, you can't use it. We are not asking for the world. We are just asking for the one exception that applies to most domestic violence cases, and I'd urge you a favorable report, and I did submit written testimony. Thank you.
Questions from the committee? I asked the same question I did before. Just, it's always interesting. You read the code, a lot of stuff doesn't make sense, but you're wondering, just in context, what was the policy reason for the delineation between?
So this really goes back to a common law of being changed it was a compromise. It's like, look, if there's a felony, come on, man, and they're manipulating. And that all predates the recording of jail telephone calls. And so nowadays, it comes on, and it obviously predates body cameras. So, if people are worried that suddenly, some people are going to get convicted that shouldn't be, we now have so many things in place. You'll be able to listen to the recording from the jail call. You'll be able to look at the body camera video. You'll be able to hear the victim speak. And so those protections are there that when the defendant manipulates the situation, we should be able to go forward with a case, particularly in the thousands of cases that happen in domestic violence.
Thank you. Additional questions from the committee?
And I didn't start until 1985, just so you know.
We're not even going to play that game. I'm not even going to. In my father's eye. Yeah, that's right. Who is from Cumberland? He is from Cumberland, that's right. All right. I think we do have. Do we have another? Yeah, two. Okay, two signed up in opposition. And all right, Ms. Stofa, you're up next. Welcome. I think we're going to have to unmute you. Hold on one second. We'll restart your time.
I've asked her.
Oh, there you go.
Thank you, Mr. Chairman. My name is Tamara Stoff, and I'm the District Public Defender for District 3, which is located on the Upper Eastern Shore of Maryland. And I'm asking the committee to do an unfavorable report of Senate Bill 146. The right to the confrontation and cross-examination is guaranteed in criminal trials by the Sixth Amendment and the Maryland Declaration of Rights. This right to confrontation is to confront your accuser is fundamental to a fair trial. It allows the trier of fact to assess the credibility of witnesses and reliability of their testimony, and it protects against false accusation. Passing this bill would eliminate this fundamental right in simple assault cases. In 2005, an exception was made to the hearsay rule on crimes of violence and felonies. These are the most serious crimes carrying the most serious penalties, and they are intentional crimes that the state believes the defendant committed. The General Assembly must have found that the government's interests outweighed the defendant's and allowed the introduction of these types of statements. These cases are often heard in circuit court, and the bill recognizes in those cases that has some protections, and in jury trials, these allegations would be heard outside the trier of the fact. Second-degree assault cases are simple misdemeanors ranging in a myriad of behaviors that don't even require injury to occur to be convicted of this crime. They're general intent crimes, they're heard in district court traditionally, and there is a judge. So the same person would be hearing the exception that we're trying to get in while at the same time trying to decide the facts. That is a reason why I'm asking the court to have an unfavorable report. A practical consideration is I think you'll see a ton of jury trial priors. And I was not, unfortunately, able to hear the presentation of the favorable recommendations, but I would remind that there's a criminal law 9302 that addresses some of the concerns.
Excellent. Thank you very much. We're going to hear from Chastity Simpson first, and then we'll take questions for the opposition panel.
My name is Chastity Simpson. I am the District Public Defender for District 2 of the Maryland Office of the Public Defender, which is the Lower Eastern Shore. So I practice in Wycomico County, Somerset County, Dorchester County, and Worcester County. Like my colleague, Ms. Stofa, I am asking for an unfavorable report as to Senate Bill 146. I would just note that in some of the language that is most concerning, I think, to me as a practitioner, is that this hearing that Ms. Stofa referred to that is heard outside of the presence of the fact finder, which typically in circuit court would be the jury, heard by a judge, is set at the preponderance of evidence standard. So we are talking about a constitutional right to confront and cross-examine witnesses being stripped away by a judge making a finding that it's more likely than not that you committed some wrong act that led to the unavailability of this witness. And that is part of the reason that we view this as a very problematic bill, very problematic language. The constitutional right to confront and cross-examine witnesses is fundamental to our system. As a practitioner in criminal law, I can tell you that I question witnesses very frequently, and it is not uncommon that what you learn in confrontation of those witnesses is that their story is not 100% truthful. They leave out details. Someone who is upset, emotional about an event that just occurred, which, by the way, I know there's been a lot of talk about domestic cases, but an assault in the second degree isn't only domestic. It can be a push, it can be a poke, it can be a shove, it can be a verbal threat to take action that someone believes you will follow through on. It is not simply a domestic violence issue. It can be a very, very minor event. But often emotions are high, and what someone says to a police officer on a body camera often is not going to include what they did or give full context to what occurred. And this bill would then allow a prosecutor to simply play that video without the opportunity to question that person about those details and to get more information and context, which could call into question the entire story that's given.
I just want to make sure that you're not implying that that's all that simply happens. First, the prosecutor has to have a statement that meets a strict criteria, and two, there has to be a hearing about it, and three, there has to be a preponderance of the evidence that the defendant procured the witnesses not to be present in court. So it isn't just, I just want to make sure that those three things I just said are correct. Is that correct?
Well, what my understanding is that the prosecutor has to present evidence. It doesn't have to necessarily be a statement from the defendant. I know there was a lot of...
Have you read the statute that
I have
already
read
applies?
the statute.
Okay. Thank you, Mr. Chairman.
Thank you very much. Additional questions from the committee? All right. Oh, sorry. I thought you were looking at Senator Henson.
Thank you, Mr. Chairman, and thank you to the panel for their testimony. I feel like there's been a collapsing of felonies and misdemeanors and the differences between district court and circuit court where those cases are heard. I feel like it's gotten lost in the conversation. Could you give us a context in terms of what it's like when there is a trial for a misdemeanor versus a trial for a felony and what those two differences, what some of those differences are?
Sure. So a charging document that includes a simple assault or second-degree assault, a misdemeanor assault, if that is the only charge and there is not a felony included in that charging document, the matter would be heard in the district court, or at least start in the district court. A defendant can ask for a jury trial in that situation. The state, I guess, could charge a criminal information into the circuit court, but the standard second-degree assault is going to be charged and then heard in the district court before a judge. And so you would have the right to a bench trial in the district court before that judge, who is the fact finder who makes the decision as to credibility of witnesses and whether there is proof beyond a reasonable doubt. If the matter were in circuit court where most felonies have to be heard and where misdemeanors can be heard if requested by the defense, there would be the right to a trial by jury where 12 persons, sufficient evidence to show by a preponderance as elicited in the current statute that there was wrongdoing on the part of the person who's made this on the part of the defendant, so that this statement could then be introduced.
I think we heard some very thorough examples of evidence that would be presented to support that there is a statement and that it was the result of the defendant that the witness was not available. But with the preponderance of evidence standard, could you give us some examples of things that aren't as clear as perhaps a taped phone call from someone who's openly threatening someone in ways that are recognizable through a jailhouse phone call? But with the preponderance standard, I'm presuming there's lots of other things that could meet that burden that aren't as clear as sort of that. Could you give us some examples of other things?
So certainly the inability to serve a witness is one way that a witness is unavailable for purposes of the statute. So whether or not the victim or the witness that the state is trying to procure the attendance of will accept service or can be found for service is one thing that qualifies that person as unavailable as a witness to testify. And so certainly evidence could be presented as to the efforts to serve that person, and then other information from other sources, I suppose, could be presented to indicate that it is the the defendant who caused that person to refuse service. I don't know. There are probably many things that a state's attorney could present, so it could be the testimony of neighbors or friends or family members who have concerns about the relationship, who are then presenting information to the state about why they believe the person is behaving in the way that they are or refusing to cooperate. I don't know what effect, so for instance, there's been talk earlier today of the marital privilege. That is also something that makes a person unavailable to testify against their spouse, potentially, if they choose to take that marital privilege. I wouldn't call it wrongdoing to get married, but I can envision a creative state's attorney making that argument to a judge that by going out and getting married so that the person is now unavailable, they have committed the wrongdoing that then allows the testimony or the evidence to come in.
My fear is that with the standard set at preponderance, that let's say you do have evidence that there were threats made, but on the morning of court, a person has car trouble, or they couldn't get off work, or they couldn't find a sitter for their kids, or they're not feeling well. Any number of intervening factors steps in, and that's the reason that the person's not there to testify. But because you have something where someone was threatened, which is, I don't know that that's going to be totally out of place in a second-degree assault. This is a history of violence there. So if there were threats made, it's the connection, the nexus between the unavailability and the threat being the direct reason that person's unavailable, that with the preponderance standard, it just makes me nervous that we're leaving the door open for other intervening factors, but then we would exercise this ultimate option of not allowing someone to confront their witnesses.
And I would just add that there are statutes that protect against witness intimidation. So witness intimidation can carry 10 years just like a second-degree assault can. And if there is in fact strong evidence that that is what occurred, the person could be prosecuted for that. And that would require a beyond a reasonable doubt standard, which is what should be required in the criminal justice system.
Thank you. Thank you, Mr. Chair.
Senator, this is Ms. Stofa. As said before, unfortunately, I wasn't let into the hearing to hear the proponents of the bill's testimony, but I did want to point out that there is Criminal Law 9, Section 302, which does deal with the inducing of false testimony or encourage the avoidance of serving of a subpoena when someone encourages them. That does, for misdemeanor offenses, carry up to 10 years and a fine up to $5,000. So almost a more potential serious crime than second-degree assault. And for crimes of violence, it carries up to 20 years. So there are avenues to address some of the concerns, a way to still prosecute a defendant if those actual scenarios are occurring without giving up this fundamental constitutional right.
Thank you very much, Ms. Stofa, and thank you.
Thank you.
Further questions from the committee? All right, excellent, thank you. With that, that'll conclude the testimony in the hearing for Senate Bill 146. We'll now move on to Senator West with Senate Bill 180.
Thank you, Mr. Chairman. It's a pleasure to be here to present Senate Bill 180. Under current Maryland law, handgun permits are valid for a 2-year period after the initial issuance date and are valid for 3-year periods thereafter. Currently, about 200,000 Maryland residents hold gun permits. This represents a massive increase in the number of permit holders in Maryland following the Supreme Court's Bruin decision. The enormous increase in gun permits has caused a concomitantly enormous increase in the cost to the state of Maryland of monitoring whether the holders of gun permits continue to qualify to possess firearms. Every holder of a gun permit is the subject of a background check each year. This includes a federal background check and a review of 17 Maryland databases. In addition, each permit holder has executed a HIPAA waiver, enabling the state to access the permit holder's mental health records, among other things. And in addition, Maryland participates in the FBI's RAP-PAC system, in connection with which the Maryland State Police receive prompt notice of an arrest of a permit holder that has occurred anywhere in the United States. All of this background checking is both time-consuming and expensive. Permit renewals add yet more expense as they are far more onerous and require far more administrative time on the part of the state police. Senate Bill 180 simply permits law enforcement officers who retired from their jobs in good standing to have their gun permit renewal period run for 5 years after the initial issue date instead of 2 years, and for similarly to have their renewal periods last for 5 years instead of 3 years. This is a narrowly focused bill that improves the process for handgun renewal for retired law enforcement officers in good standing and recognizes their years of training and service and good standing. It will also help to reduce the magnitude of the expense that the state police will be put to as they deal with the logistics of handling renewals of gun permits for hundreds of thousands of Maryland citizens 2 years after permit issuance and every 3 years thereafter. Given the ongoing background checks of all permit holders that occur annually, certainly law enforcement officers who retired in good standing constitute a group who need not go through the renewal process every 3 years. Some have suggested universally extending the 3-year renewal period to a 5-year renewal period for all 200,000 permit holders. This bill does not do that. It's limited to those permit holders who are well-trained in their use of firearms and who have served the state with distinction and who have retired in good standing. It represents a reasonable measure to acknowledge the contributions of these retired law enforcement officers while at the same time reducing the cost to the taxpayers of the permit renewal process. So I have with me to talk about this bill 2 witnesses, Dan McCord, who represents the Maryland State Police Alumni Association as well as the Maryland State Troopers Association, and Clyde Boatwright, who is the leader of FOP Lodge number 5. I turn it over to them, and then we'll take questions.
Good afternoon, Mr. Chair, members of the committee. My name is Clyde Boatwright, and in addition to my role as the president of FOP Lodge 5, which is the Baltimore City School Police, I am the president of the Maryland State Lodge that represents 21,000 police officers across the state of Maryland. My testimony today is in support of Senate Bill 180, and also we've reached out to Senator West's office to offer a couple of amendments that we would like to see, and those amendments include adding active duty police officers to this. The reason why we're adding active duty police officers is because some police departments require active duty police officers to obtain a handgun permit in order to work secondary employment, such as working at your local Home Depot or Walmart stores. The police department feels as though that the liability is on the security company or agency that you're working for, and therefore you have to obtain a gun permit to work there. We're also asking to put a little bit of some guardrails on our local police departments because when a police officer is listed in good standing, there is no justification needed to list someone in good standing or not. And let me tell you how it's being used inappropriately. I have 30, I'll just say if I'm eligible, for an example, I'm eligible to retire and I have 30 years of service. And I inform my police department that I'm thinking about retiring and going to another police department. They can list me in good standing with no hearing to prevent me from moving on to another police department. And so we're asking that we put some guardrails on that. And the only way that a person could be listed as not in good standing is if they're facing termination. So with that, I'll urge a favorable report. I had my legislative chairperson, Angelo Casoli, submit a letter with those changes, and we are in full support of this piece of legislation. I'll be happy to stand for any questions. Thank you.
Mr. Chairman, distinguished committee members, my name is Donald McCord, and I'm a retired lieutenant from the Maryland State Police. I'm testifying today on behalf of the Maryland State Police Alumni Association, as well as the Maryland Troopers Association, in support of Senate Bill 180, extending the renewal time for our handgun permit from 3 years to 5 years for retired and law enforcement officers. The Maryland State Police alone are charged with, by law, conducting handgun permit investigations. With more than 85,000 applications noted in 2023, this presents a daunting task. A trooper's time and man-hours, salaries, equipment wear and tear, and fuel costs are just some of the expenses to be considered. Given the volume of applications processed, many of these investigations are conducted on an overtime basis to avoid taking time away from more pressing and time-sensitive criminal investigations. This puts an even greater demand on overburdened police resources and budgets to investigate unknown, highly trained, law-abiding individual who has served the state and their community with honor and distinction. In addition to the points mentioned above, this bill, if passed, would bring Maryland in line with our neighboring states of Pennsylvania, Virginia, and West Virginia, in addition to providing a significant savings to the state of Maryland. As an active duty or retired law enforcement officer, we are held to a higher standard by the community at large, with much greater expectations of conduct and character, especially in times of trouble. Those of us who have chosen to pursue the path of a law enforcement officer embrace these expectations and live their lives accordingly. Given the dedicated years of service and sacrifice to the state of Maryland and our communities, we would appreciate your consideration in extending the renewal time for our handgun permits from 3 years to 5 years. Thank you.
Thank you. Mr. Boatwright, your testimony actually triggered a question that I was going to ask initially Senator West. But could you talk a little about what is good standing? Because you were talking about guardrails, and that, could you help me?
Yeah, so as we know that police departments are facing shortfalls, and, you know, they come up with attractive packages for people to move. And one of the tactics used by some police departments is to list someone in not good standing for a uniform violation or something like that, so that they can't move from police department to another police department. So they are forced to stay. Essentially. And so when we see the use of good standing, it's overused in some cases. And so we wanted to, like I said, put guardrails to limit the use of that by police departments, to just limit it to people that would be terminated. So we support, if someone's under investigation or being looked at for something that would be a terminatable offense, then they should not be listed in good standing. But simply a police officer failing to report to an overtime duty shouldn't be listed in not in good standing, and that's what happens frequently across the state.
Is there a standard from the Maryland Police Training Standards Commission, or is good standing subjective? That's what
it's
you're
subjective.
shaking your head, it's subjective.
Yeah, based off of the police department. Whoever sends off the notice of communication to the training commission by order of the police chief or sheriff, they follow that order and send off that the person's not in good standing.
Okay, thank you.
Thank you, Mr. Chairman. Thanks for coming here. Thanks for testifying on the bill. Is it true or not that some agencies, like you were saying, I just want to make sure we get a pretty good picture of this, but there's agencies, because of the turnover within law enforcement, that for these infractions, they'll even watch them coming out of a parking deck and see that they don't have a seatbelt on. They'll open up an investigation on them. And because there's an open active investigation, MPTC is not able, because of how it's classified, to move their MPTC card to another agency.
That's correct. If a person
and those agencies can hold that investigation open for a year.
Yes, that's correct. And you know, most times.
And now under current time, I'm sorry, I don't mean to cut you off, but now under current time, and the piece of legislation that we will see later in session is that because there is no time frame for some of these agencies can actually bring action from offenses that happened 20 years ago.
That's correct.
Under the current letter of the law.
That's correct.
Even for an administrative sanction 20 years ago, not criminal.
That is correct.
Which would hold up this whole process. Thank you.
Yes, sir.
Excuse me. Further questions?
Let me just add, if I could, to this. I was not aware that these kinds of things exist. And I would be happy to work with Mr. Boatwright in order to design an appropriate amendment to the bill to make like every 3 years to get the permit as opposed to every 5.
Further questions from the committee? No, good. It seems as though everyone that would qualify for our Maryland exception here for the 3 years now, and you want to make it 5 years, would also fall under LEOSA. Now, does LEOSA require a retirement in good standing?
LEOSA also, you'll see active duty officers, law enforcement officer, they're basically required to maintain the same level of proficiency as an active duty police officer.
So do you find that most people that retire in the state of Maryland will opt for our state renewal, our exception, wear carry, as opposed to maintaining their status under LEOSA?
It's not, LEOSA is not offered to every police officer that retires. Not all, because some of our smaller departments just don't have the budget to fund, sending people to the range and things like that. So all police officers are not afforded that opportunity to get LEOSA.
Excellent. No, that's fascinating. I didn't know that. The good standing thing, we'll have to talk about that because that kind of, that seems like that's a personnel issue that, the union's gonna have to deal with, the higher ups on that. I'm wary to get rid of the good standing piece, but we'll talk more about it.
The MPTC leaves it open to, I'm sorry, Mr. Chairman.
No, go, yeah.
Leaves it open to the police chief or executive on their interpretation of it, and they're allowed to tell MPTC how to hold the person's file.
Wow.
That's the problem, because if the standard was written at MPTC, I think it would be much clearer.
Yes.
But because it's left up, if you have a chief or a sheriff that's upset with an employee, that they found out somebody came and did a background investigation because they're looking to leave, what are they going to do? A lot of them, because they can't afford, they don't want to lose personnel, they open up an investigation on them.
Well,
and they're not transferable then.
Yeah, we should address that through the MPTSC. I mean, honestly.
Yep.
But it's another issue. So yeah, all right. We'll keep talking.
Thank you.
Excellent.
Thank you so much.
Appreciate it.
All right.
We'll be in touch.
Yes, sir.
Thank you, Senator West. With that, that'll conclude the hearing for Senate Bill 180. We'll now move on to Senate Bill 38.
Yes, thank you, Mr. Chair. It's a pleasure to be here to present Senate Bill 38. This bill passed the House 3 years in a row, but it's always failed to get a vote in the Senate. It's also that rare criminal bill that has the support of both the Maryland State's Attorneys Association and the Office of Public Defender. Further, this bill has no fiscal note. Emphasize, no fiscal note. Senate Bill 38 changes a single word in a single criminal statute. In Section 10-402 of the Courts and Judicial Proceedings article, it changes the word felony to misdemeanor. The penalty for the crime is left unchanged. All the changes is the characterization of the crime from a felony to a misdemeanor. The crime set out in the statute is the crime of intercepting a communication, whether oral, wire, or electronic, without the consent of the other parties to the communication. Unlike in most other states, Maryland has a two-party consent rule. Both parties to a communication must consent to its being intercepted. So this bill would change the characterization of that crime from a felony to a misdemeanor. Let me give you 2 hypothetical instances which this bill would impact. First, 2 gang members are standing on a corner discussing a crime they're about to commit. Someone standing nearby waiting for a bus takes out his cell phone and makes a video recording of their conversation, including an audio recording of the words they use, and then turns the recording over to the police. Under current law, that bystander has committed a felony. Second, a battered wife sits her cell phone in a location in her house that can capture video and audio images of her husband and captures footage of him screaming at her and beating her, and then turns the footage over to the authorities. Once again, under current law, the battered wife is guilty of a felony. Senate Bill 38 is a simple but necessary step to align Maryland law with the reality that cell phones and cell phone recordings are commonplace. The felony criminal liability imposed by the current statute is out of touch with the expectations and experiences of Marylanders. Reclassifying the violation as a misdemeanor brings the additional benefit of permitting these cases to be tried in the district court, a more efficient and appropriate venue for most of these matters. It thus reduces the strain on resources of the circuit courts. In the House bill last year, this bill drew no opposition testimony. In support of the bill were the Maryland State's Attorneys Association, the State's Attorneys of Baltimore County, Frederick County, and Prince George's County, the Office of Public Defender, the Maryland State Bar Association, the Women's Law Center, and the Maryland Network Against Domestic Violence. So I appreciate the committee's consideration of this bill. And now I think Laurie Ruth is standing by video so she won't infect the members of this committee. Every time I've talked to Laurie about this, she's had this same cold. And I said, Laurie, when I see you in the committee room, I'm going to wave at you, but I'm not going to give you a hug. So I can't even wave at you, I guess. But it'll be good to hear your testimony. Thanks.
Welcome, Ms.
Scott, you're going to
Welcome back.
I'm ready.
Okay.
Thank you, Mr. Chair, and thank you, Senator West. As the senator said, my name is Laurie Ruth. I'm the Public Policy Director at the Maryland Network Against Domestic Violence, and we are the coalition that represents victim service providers and allies and individuals in our efforts to reduce intimate partner and family violence. We have supported this bill in the House for the past several years for all of the reasons that Senator West indicates, but it's not limited to only domestic violence or criminal, it would affect other criminal charges as well. And most of all, the network has been supportive of efforts to, as Senator West said, be in step with today's reality that don't single out domestic violence or intimate partner violence. So to me, I think Senator Sydnor has been very involved in trying to address some issues with our two-party consent laws, our wiretap laws, to bring them up to sort of modern standards and recognize reality. And I'm delighted that Senator West is also interested in this. And this bill is a easy one in my view. And so we recommend a favorable report. Thank you.
Chairman Smith, members of the committee, Scott Schellenberger. I have, for the last 10 years and maybe more, been down here trying to ask you to repeal this statute. And since I've been unsuccessful, I have decided to agree with the approach of taking baby steps. And today, Senate Bill 38 is one baby step. So if Senator Sydnor and Senator Folden were in the back room and they got into an argument and some exchanges happened, and suddenly Senator Will Smith pulls out his phone and starts recording it, it's very much a potential, since that's not a public place, that Senator Smith has committed a felony. Yes, ladies and gentlemen, every time you're watching the news at night and you see somebody doing this and recording, not the video, everybody can record video, but the audio, they are committing a felony. We need to change a statute that is criminal CJ 10406 that has the word switchboard in it. I mean, talk about being behind the times. How much more behind the times can we be? And so all these people who are recording audio, they have absolutely no idea that they're even committing a crime, let alone a felony. So as much as I would love to see CJ 10406 disappear, I know that that's not going to happen since I've tried so hard. 38 states are one-party consent. That is, one party can consent to the other ones, to recording. And so when I pull out my phone, that's my implied consent that I can do it. And you know, I can't tell you how many cases that this has affected, and it makes absolutely no sense in this day and age. So let's take a baby step, pass Senate Bill 38, and then we'll work on number 61 next.
Mr. Chair, I can't recall, is this a bill that where we only can have two proponents, or can I have a third? Great, come on up.
Hi, Chairman Smith, members of the committee. Brett Engler, again with Frederick County State's Attorney's Office. On behalf of my office and MSAA, we support the bill as well. I don't have much to add other than what Mr. Schellenberger said, but I have had cases and frequently do have cases in the domestic violence realm where a victim has recorded audio of her abuser, possibly her abuse even happening. And if the abuser knows anything about the law, he tells her she's committed a felony, and you know, the power and control continues, the terror continues. And as we've said, this is very commonplace. People record each other all the time. They don't know they're committing a crime, and we don't feel that it should be categorized as a felony any longer. Thank you.
I just want a little clarification, and I see the problem. One, I should really let the new senator address this, but it made me think about the case we had the other day where the neighbor, well, I'm not sure who brought this either. Maybe you were just asking me. Somebody brought a case, a bill in here where one neighbor was putting up cameras everywhere on their property and recording.
Senator Corderman.
That's right. Okay, sorry. So that just came to mind, okay, because that to me is intersected with this bill a little bit. And the other one is, not being a criminal lawyer, that idea that back there in the back room, I think that's relatively private. I could be wrong, but do we have an understanding what's private versus public?
I'm going to let you answer this.
Because that maybe that's the thing that's giving me a little heartburn. I'd like to think that not everywhere I go, every time I speak, just because, you know, that it's public and that I can just be recorded all the time and maybe even have a tape and manipulate. But I don't know where the line is, and maybe it's in here or what. But cell phones are begging this issue, aren't they, to some extent?
So what it is, it's your expectation of privacy.
Okay.
And so that is, you know, if you're at the Walmart and you're walking around, then you're in a public place. You don't necessarily have an expectation of privacy.
I do if I'm walking with my child and I'm having a conversation that's in a low voice, and I don't expect anyone to be listening to it now. And that's where I have a problem.
I'm fine with that.
Okay.
But the difference is, it has everything to do with expectation of privacy. Okay. And because of this law, most of the stores that have security cameras are video only. They don't capture audio.
Right, that's why I thought we
and so most of them have only video. And what this bill does, it's not saying, Senator James, we're not going to protect you and your child's privacy. Yeah. But we are saying is, if we do happen to record it, it's not a felony. Yeah. And that's the difference. So we're not taking the law away, like I've always wanted. We're not taking the law away. We're saying the law is still there. If you have an expectation of privacy, then they could still be prosecuted. I'd be really interested to see how many cases have been prosecuted in the last 15 years in the state of Maryland under this statute. Most states' attorneys aren't going to do it.
Mr. Chairman, I do know the concept of expectation of privacy. Why I asked is I didn't know, because we're in this detail, if we had defined public anywhere for the purposes of this statute or elsewhere with this growing issue of cell phones and the like, or if there's bodies of law that are coming up with it. But as far as you know, we're still with the expectation of privacy.
Right, not to my knowledge. Okay. I know that there have been case law. My recollection is there was one a couple years ago where somebody recorded police officers eating lunch in a McDonald's, and then that actually turned into a case, and whether that was something that you had a reasonable, the key element was, do you have a reasonable expectation of privacy?
Very good, thank you.
Yep.
Thank you.
Senator Love and Senator
Thank you, Mr. Chair. Good afternoon.
Good afternoon.
Mr. Schellenberger, good to see you.
You too.
Of the other 11 states that have a two-party consent, are they felony or misdemeanor?
Good question.
Thank you.
No answer.
All right, then. I'm done, Mr. Chair.
I'll beg my friend Jamie Lancaster to maybe check that out.
There you go. I want to know.
Hey, I helped him with one yesterday.
No, thank you. No, it's news to me that you've been trying to get rid of this so many years. So I'm curious, your argument for getting rid of this statute.
It's just not realistic in this day and age. And more importantly, you know, to have a domestic violence case and to have your victim come into your office and say, look, listen to what he said. He admitted that he hit me the other day. Listen to that. And I have to say, don't play that or you're going to commit a crime. You're going to commit a felony. And so not only do I tell them not to play it, but I can't go down to the courtroom and play it. And, you know, in this day and age where we're trying to bring the best evidence forward, we're saying that a recording can't come in. And again, I'm not going back to where I was, where I kept saying we need to be a one-party consent state. What I'm saying is let's take this baby step and make it a misdemeanor instead of a felony, because it's so unrealistic that you could get convicted of this and get a 5-year felony. It just doesn't make any sense.
How many cases that, or do you even track how many cases could be brought by your office that are undermined by the current law?
You know, that's something that I really can't track. I'm sorry. But if you remember, when we launched body cameras, you all changed this statute and said, oh, body cameras, we got to make an exception for police body cameras when they walk up to you. So, you know, they're coming up to you, they hit the button, they say, oh, you're being recorded. We had to make an exception for body cameras when they came out. So again, the best evidence possible, you know, we're relying on a law that's decades old, and we have to change it so that we can do what's best in the interest of justice.
Thank you.
Thanks for coming out today. Always a pleasure to see you. I'm just curious. So, you know, I have just being on different domestics and working with Ms. Engler for a long time. This is it's a safety thing. This is a huge safety thing. When we're talking about domestic violence specifically, we're living in a time where everyone has a mobile device that not only can record, but can search the internet from its place. I mean, the days of having to sit at a hard top desk are gone.
Yeah.
We've evolved. So I just have a quick question, and I was trying to run this through my brain the other day, and I couldn't remember what the actual outcome would be. So I'm curious to ask you. If we have someone, like I believe probably similarly, that if you feel that you're in serious threat of bodily harm or injury or death, that you should be able to at least turn it on, and even if you have it, and be like, look, it's obvious I was in physical serious and have concerns for my own safety. You can hear it there in the volatility. You can, like, I think that there should be exceptions.
Right.
And in those moments where you have a serious fear of you know, serious bodily harm or death. If someone who has been abused, has a history of abuse and has been abused in the past, recognizes it, like they said, before they come and tell you that they've recorded it, if they tell you they record it, they've committed a crime.
Right.
If the person ultimately dies as a result of the assault, and the police take their phone and they play it from the notes or from the recording, and the person has expired, has died, is it admissible then?
No.
Still not admissible?
Nope. Because you're not supposed to record as long as there's an expectation of privacy, meaning you're in a private place. I mean, me standing here, I know right now I'm being recorded. I know that right now that I'm being recorded.
That's your consent.
I'm sorry? Thank you. But, and then again, now we're in the, the Walmart, yeah, now we're starting to, but, if it's a domestic and you're in the privacy of your own home.
Or in a vehicle.
Right, or in the car with them or
A lot of
whatever.
them happen that way.
Then you would be able to argue that there's an expectation of privacy, and it wouldn't come in.
Thank you.
The senator's point, begs for a more narrowly tailored solution, which I think we're going to entertain later on. And I tend to agree with that. I'm very protective of the statute, as you know, something that, and as Senator Sidnor knows. And you're right, the question does turn on privacy, as the two examples between Senator James and your example. So the prior example of me sitting back here with my cell phone recording two other people bickering, but there's no expectation of privacy there. I'm not sure that falls under this, but maybe yours does, because you're depending on the circumstances. And then so I'll send you this case site, but we found it. It's Bedford. So the expectation of the expectation of privacy, questions of the expectation of privacy are decided on a case-by-case basis.
Okay.
But so, and then the definition in the statute for oral communication means any conversation or word spoken to or by any person in private. So this whole thing turns on privacy. I personally am very protective of the statute because I want to know that I'm not being recorded surreptitiously, or I have that protection when I move through life. I'm on a phone call, this, that, and the other. Now, your public safety concern, I think, begs for a more narrowly tailored conversation that we're going to have later this session, I think maybe even next week. And I'm actually supportive and open to that.
Okay.
And so, but,
and what
we've done some other things too, in the interest of housing and civil rights. But I think generally I like walking through life knowing that there's I have some sort of protection in a private conversation.
Okay.
As a policy matter.
And Senator Folden.
Yes, sir.
In light of what Chairman Smith has said, when you go back into his office later today and close the door, would you mind putting your phone in your pocket and recording when you ask the question? What do you think about Mr. Schellenberger now?
No expectation of privacy?
None whatsoever.
No, you close the door and there's two people, there's an expectation of privacy right there. But if there are 4, 5, 6, 7, 8 people hanging out, there's no expectation. Come on.
Arguing people draw a crowd.
Well, then we'll have the judge decide what it is then. All right. Well, thank you. I think we know where this bill's going, but I'm not, we'll see what the next one does.
This bill's moving
I
forward.
appreciate it. Thank you all. Yes, Ms. Ruth.
I just wanted to answer Senator Love. Since I'm sitting here at home, I went online and I got through about 9 of the two-party states, and it's a mix. Some have it's a 3rd-degree felony, a class 4 felony. Some it's more nuanced than that. One has a 6-month maximum jail sentence. So it seems to be a mix from what I saw, just for Senator Love's information.
We should get that.
No, I appreciate it. Yeah, we'll get it. We'll get it. Thank you very much, Ms. Ruth.
Thank you.
All right. I believe that is the last witness, and that will conclude the testimony in the hearing for Senate Bill 38. We'll now move on to Senate Bill 61, our last bill of the day. Senator West.
Thank you, Mr. Chair. Again, it's a pleasure to be here to present Senate Bill 61, and Senator Love may recall yesterday that I made a note in connection with Senator Sidnor's bill when you asked him the question, isn't this the first civil exception to the two-party consent rule? And I interjected and said, well, tomorrow you're going to have another civil bill. This is that bill. So let me present the bill and then we'll talk about it. So this is a companion bill to Senate Bill 38. Senate Section 10402 creates the crime of intercepting a communication, whether oral, wire, or electronic, without the consent of the other parties to the communication. This criminal statute was adopted before the invention of cell phones and before the invention of most home security systems, using cameras and other sophisticated electronic devices to record people entering upon someone's property. In today's world, with ubiquitous cell phones and security systems, protecting private property, the Maryland statute is increasingly innocently violated by ordinary citizens and homeowners. The use of cell phones to record people occurs all the time, frequently and maybe most frequently without the consent of the people being recorded. Of course, cell phones recorded both images and audio, so it's probably not an exaggeration to state that most people possessing cell phones at one time or another have committed a crime under Section 10-402. Similarly, many homeowners have installed more or less elaborate home security systems that capture the images and frequently the sounds of people entering upon the homeowner's property. The rapid proliferation of doorbells that capture the images and sounds of people approaching the door and seeking to speak to the homeowner is well known. Other even more sophisticated systems protect the backyards, garages, and other points of possible entry of private homes, and even are installed sometimes inside the private home, for example, in the dining room where the family silver is kept in order to capture the images and the sounds of anybody coming in there to take away the family's silver. Any such systems that capture sounds render the homeowner and person installing the system in inadvertent violation of Section 10-402. So Senate Bill 61 addresses this problem. It creates an exception to the prohibition contained in Section 402A by establishing that it's lawful for a person to use a cell phone or other device to intercept an oral communication in public if the person speaking in public should reasonably anticipate that the oral communication could be overheard or intercepted. And it further provides that a person can lawfully use a security device or other device installed on or about real property owned, leased, or otherwise controlled by that person to intercept an oral communication on the property. Now, in a conversation I had yesterday with Ms. Ruth, yes, Ms. Jordan, we discussed the verb installed. The concern was expressed that installed sounds like it would have to be affixed, with screws or nuts or bolts or something. So I suggested I'd be willing to change this proposed statute and use the word placed instead of installed. That would allow someone to place their cell phone in a place where images and audio of a husband coming in to abuse the spouse could be captured without the cell phone having to be installed in some way in the house. Also, we had a conversation about a bill introduced in the House by Delegate Grammer, and I admitted that I haven't had a chance to do it, but I will, after this hearing, go back and read Delegate Grammer's bill and consider whether or not we should try to incorporate Delegate Grammer's bill into this bill in some way. I'm not sure that that's a good idea. I took a quick look at it, but at least we'll talk about that as a possibility. So with that, with those comments, I now am going to give it over once again to Lori Ruth and also Scott Schellenberger for their comments. Oh, I'm sorry.
Robert Ossicow.
And Robert Ossicow as well. Laurie?
Can't hear.
She's Laurie's not on. She needs.
Ms. Ruth, sorry. Yeah, there you go.
Muted, sorry. Good afternoon, Mr. Chair, and thank you, Senator West, for having me here today. I am the Public Policy Director at the Maryland Network Against Domestic Violence, and we're here in support of this bill. Although I think Senator West recognized yesterday when we were talking that there are some small details. To echo Mr. Schellenberger in the prior bill hearing, these are all sort of baby steps. Delegate Grammer's bill is a different approach to a baby step to try and face reality about people's cell phones and the fact that sometimes the best evidence is not allowed to be put in front of the fact finder in court systems. And so SB 61 would be an effort to make it lawful in certain circumstances, as the language of the bill indicates, to record somebody's audio so that they would not be subject to the criminal justice system for doing it when, as Mr. Schellenberger said just a few minutes ago, everybody's doing it all day long and don't even realize that they're committing a crime. So Senator West has in Senate Bill 61 has an effort to recognize those circumstances where it would be relevant to have it in the case. And I'm sorry, I'm losing my voice. I'm going to stop just because I can't catch my breath and talk. So we support SB 61, although we're happy to continue discussing any amendments. And we are also going to support HB 314 by Delegate Grammer.
Excellent. Thank you very much, Ms. Ruth. Get well soon. Yeah, no, thank you very much. Get well soon.
Thank you. Scott Schellenberger, State's Attorney for Baltimore County. I'm sure it's often that you wish that I was losing my voice too, but you know, I don't want to belabor this point. We've really kind of covered it, and this really covers the C12 really covers the situation that we were talking about, and that is at least in these public places to be able to record the audio. And what it does is it incorporates the concept of an oral communication in public if the speaker should reasonably anticipate that the oral communication could be overheard or intercepted. And then number 13, I like the word placed instead of installed. I was just thinking Ring camera. I wasn't thinking propping your phone up in the bedroom. So using the word placed does make a lot of sense. I think these, again, are two pretty reasonable baby steps between 61 and 38 to at least bring us a little closer to 2025 as opposed to 1930.
Thank you, Mr. Chairman, and Senate committee members for allowing me the opportunity to testify. My name is Robert Osikow. I'm a 30-year resident of the state of Maryland, here to testify regarding Senate Bill 61. And the main reason why I'm here today is I've seen firsthand the modern application of this current law that was written in the 1970s and the devastating punishment as a result. A family member of mine was recently tried and convicted on 4 felony counts of breaking the law in the current statute. His crime was having security cameras in his house and intercepting communications each time the motion sensor went off on the camera. His intent was to capture video of property being stolen from his house, not to electronically intercept communications. As a result of this felony convictions, he will lose his license in the healthcare profession and no longer be able to earn a living. This law in its current form could conceivably result in tens of thousands of Marylanders to be prosecuted for intercepting communications because they have security cameras in their homes or on their doorsteps. 75% of the people I know have security cameras inside their homes or Ring cameras at their doorstep. All these people potentially are in violation of the current law. The law needs to be, I'm asking that the law is updated to protect property owners or renters and not prosecute them. Reclassifying this crime from felony to misdemeanor also, based on the last bill, would furthermore protect owners of these security cameras. The original law was intended to prevent people from willfully intercepting communications on landline phones. A lot of effort had to go into tapping a phone back in the 1970s. In today's world, with the proliferation of cell phones and security cameras, it's very easy to inadvertently intercept communications between two people that are in the same room, not on opposite ends of a phone line. These technologies exponentially increase the number of potential violations by property owners and or renters or cell phone owners across the state of Maryland. Millions of people own cell phones in the state. Thousands own security cameras. Estimate each time the camera turns on due to the motion sensor, the law is violated if a conversation is happening between two people while that camera records the conversation, even if only for seconds. I'm asking you today to please pass both bills and eliminate the possibility of other Maryland residents being prosecuted and convicted under the current law and the devastating consequences that follow. Thank you for the opportunity to testify.
Thank you. Gentleman who just testified? Yeah. I have a couple questions for you. Let's see. Which county Is that the question? Now, you know what, it couldn't have been Baltimore.
when we were done.
No,
Which county did this happen in?
I'm a Baltimore County resident. This happened to a family member that owns a property in Worcester County.
Oh, there you go.
Got you. And just out of curiosity, time frame when?
This happened 2.5 years ago.
Oh, thank you. That's ridiculous.
Really? I agree. Thank you.
Very sorry.
Thank you, Mr. Chair. I have a lot of concerns with this bill. Along with some of my other colleagues, I feel very strongly that we should be able to exist in this world without being recorded at all times. Specifically, going back to Senator Quarterman's bill yesterday of the person who was putting up cameras on his own property, looking into someone else's property. Now, were he to put audio on those cameras, the language here would allow that. And so he would be able to record those teenage girls on their own property, in their own space, because this camera is on his property. So can you address that?
Yeah, sure. I'm not sure that's right. So there are Supreme Court cases that have held, and I'm not a constitutional lawyer, but I've read the cases in years past, that very sophisticated devices that enable you to film from a far distance, film with using telephoto lenses, stuff which people think is private because it's occurring inside their houses, but the telephoto lenses will look into their houses, would be along the same lines of this guy who's in let me give you another example. We have directional audio devices on football games so that you can hear exactly what the umpire says out in the middle of the field when he's talking. But those are specialized, sophisticated devices. I don't think that the courts would say that this bill would enable someone to use highly sophisticated devices to invade. What I say in the cell phone one is if the speaker should reasonably anticipate that the oral communication could be overheard or intercepted. So in Senator Quarterman's bill, I don't think the people who have the little kids out there raising their animals in the backyard should have to reasonably anticipate that a neighbor is out there filming the kid.
So a court construing this statute, your contention is that they would strike it down because you're not allowed to hone in on something. What I'm saying is, as written,
this is an exception to the rule.
But as written, this bill would allow that gentleman, or I don't know if gentleman is the proper term, that person, to put audio on his own property. I'm not talking about some enhanced device. Audio on those cameras that would record those children, because it is lawful under this title for a person to use a security camera or other device placed on their real property to intercept an oral communication on the property.
On the property.
Hang on, let me finish. Let me finish my sentence.
Sure.
So on the property is not defined. So is it the speaker has to be on the property, the camera has to be on the property, the noise could be heard on the property? That of in itself is not clear and could be read to say if the camera's on the property and the noise floats over into the property, you're just fine. And the same thing with, the Ring camera that's right up on the sidewalk. If I'm walking by and I don't see anybody around me, and I am having a private conversation with my daughter, and the Ring camera picks me up, that's not okay either.
Well, let me ask you this. Would you feel more comfortable if I were to amend the subpart 13 to deal with this issue about the camera on the property? Would that make you feel comfortable supporting the bill?
Senator, no. I'm going to be perfectly honest with you.
Okay. Well,
but I wanted to raise, since Senator James had brought that up,
I think it's a good question. Let me go back. I'll check the bill to see if I can amend it in a way which would make that question academic.
Okay.
Even though it doesn't change your opinion of the bill.
Thank you. Thank you, Mr. Chair.
address. I was gonna get my shotgun and I was gonna go up there and just blow them all off the tree, everywhere they were, and he wouldn't give me the address, so.
I might remind you that we're on. Oral communication is being
I don't want to ask a question, so I could phrase it, isn't that so? But following up on the Senator, and following up on what I said earlier about worrying about the earlier bill, now it's just another one. I'm not trying to make this, I see what you all are doing, I support it conceptually. I'm also thinking about recording of children. And now I'm starting to think that if we're going to start easing up two-party consent, right? Children really, I'm not sure how we would deal with that, but I don't think you can ever ask a child to consent. And if I'm having a conversation with my child or my children are talking among themselves, I don't really want to open that door up either. So I'm not shutting this down. I'm more saying let's think about it as we move forward in this brave new world of cell phones and whatnot and cameras on your property.
Well, apparently 38 states have thought about it.
And they could be wrong, too, really wrong, or insensitive.
I guess it's possible 38 states are, but I can tell you that they, that existed as one-party consent for decades. That's not like it's a recent change. That didn't come about because of cameras.
So in one-party states, you can go ahead and record a 5-year-old, a 7-year-old, a 10-year-old. Is that how that law works?
It's my understanding that in one-party consent state you can. They may have other crimes that they've passed, but
I'm not trying to be difficult, but I think we should look at that. Because
I mean, the thing that's interesting is that this statute was really initially designed so that people wouldn't, listen to conversations on the switchboard, but it was really aimed at the police. And so, I mean, this is also the section of statutes that we use when I want to do a wiretap. And so this is the part about, not wanting the police to listen to you. But all of this was created before we had these little devices in our pockets that record everything. I'm just saying, whichever ones we pass, we need to get into this, frankly, this century, not this decade.
You're right. You're right.
I know, we're talking about the times when you had like party lines, where you have a switchboard operator connecting, and your neighbors could listen in on the conversation.
No, I don't remember that.
You don't remember that? All right. I always think the proliferation of new technology makes the statute all that much more important, but that's just my opinion.
If there are more questions, let me just conclude by saying that the illustration we got over here was horrifying, and I have to believe that no one on the committee thinks that that ought to happen, that somebody ought to be prosecuted and convicted of a felony and put in jail for doing something innocent that everybody does. Now, there may be this is one of those bills that's the devil's in the details, and we need to futz around with the details. But overall, the important thing I'm trying to suggest with both of these bills is that right now, people every single day, in fact, most people at one time or another have committed what the law characterizes as a felony. We need to change that. It's just out of sync with modern times. Thank you.
Senator West, you said that the gentleman, his relative was incarcerated?
No, he actually he got a 4-day suspended sentence.
Okay. I mean, again, I think it's ridiculous that he was prosecuted, but if he actually went to prison as well.
But he now is branded a felon. We know other people in this country are felons as well.
You mean the president? I'm sorry.
He's not the president yet. So I definitely, sir, thank you for coming up to testify, and we definitely, obviously, no one supports that outcome. It's definitely an unjust outcome, so I appreciate you lending your voice to this debate. We'll get more offline, but I'd like to hear more about some of the facts of that case, because I don't know who would have prosecuted that. That's just wrong. I mean,
it's incredible.
Yeah.
I will try and find out.
Yeah.
Yeah, I'll try and find out. You said Worcester County?
Worcester County, yes.
I'll find out.
Yeah. All right, further questions from the committee? Yeah. All right. Thank you all very much. With that, that'll end the hearing for Senate Bill 61 and our hearings for the day.
Yeah. I think it's pretty clear. I'm gonna get that. This other one is a little more squirrely. You can see. Yeah, I can see. There's many people